I'm very excited to introduce our speakers today. As I said, I'm at Deborah Boys in Plimpton, and immediately to my left is Sean Murphy. He's a Vice President and Deputy Chief Compliance Officer in the Legal and Compliance Department at EIG. Before that, he was a Vice President and Counsel at BlackRock, where he advised on various commercial, regulatory, compliance, and transactional matters. And Sean is based here in Washington, right? Great.
Right.
Yep. And to Sean's left is Chris Mulligan from the Securities and Exchange Commission. Chris is very recently, I think it's just as of yesterday, the investment advisor, private fund senior advisor in the Division of Examinations at the SEC. Congrats, Chris. He's involved in risk alerts related to private funds, investment advisors. He advises on rulemakings, counsels examiners, on legal issues and enforcement referrals, conducts exams, trains staff, and develops exam initiatives and priorities related to private fund advisors. It's a pretty long job description there, Chris. He does seem very busy these days. Before that, Chris was in private practice, counseling private equity advisors and institutional investors with respect to fund formation as well as regulatory issues. And last but certainly not least is Andrea Santoriello. She's an executive director and assistant general counsel at JP Morgan Asset Management. She also serves as chief counsel for JPMAM's private equity group and advises JPMAM on strategic transactions and proprietary investments in diverse emerging markets. Andrea is also the vice chair of the IAA's Private Equity Fund Advisors Committee. Thank you, everyone, for being here. As everyone knows, we have a number of important developments to run through, so we're going to dive right in. Just in terms of structure, we're going to start with a discussion of the private funds rule proposal that came out at the beginning of February, and then shift to the January exams risk alert with which Chris was fairly significantly involved. And finally, if we have time, we hope to touch on the PF proposal as well. I think Monique is somewhere out there taking index card questions if there are any. We're going to try and shift those to the end of the session. So hopefully we will be able to get to some of those as well. So turning to the private fund compliance proposal, I'm not going to steal the show from our presenters, but just sort of a brief overview. You know, I think as no doubt folks in this room are aware, the SEC proposed some fairly sweeping new changes at the beginning of February that will affect all kinds of private fund advisors and could really change the regulatory landscape for funds. The proposal includes a number of prohibitions that, if adopted, would prohibit certain commercial terms, would require additional disclosure and additional reporting. It also requires advisors to document their written compliance reviews under Rule 20647. So, Chris, maybe I could start with you. Could you give us a little bit more background on the proposal, the primary areas of focus, and sort of what the issues were that the SEC was trying to address?
Sure. Thanks for the question, and I'm happy to be here. First, let me say that the views I express today are my views and not the views of the commission or any of the commissioners, and don't necessarily reflect the views of them or any other members of the staff. They are just mine. Let me say a few things about the private fund proposed rule. First of all, it is a proposal, right? So everyone can calm down a little bit. It is a proposal. And I'm in the Division of Examinations, and so that means obviously we are not examining for compliance with this proposal. It is awaiting comment, which I'm sure there will be many, probably many from folks in this room. So it is working through the process, and it is out there for all to review. That said, I will go over just kind of a very broad overview of the proposal, and then I want to talk about some issues around compliance that I think are relevant, sort of irregardless of this proposal. So the SEC proposed new rules and amendments under the Advisors Act to enhance the regulation of private fund advisors. The proposed rules would, one, require private fund advisors registered with the Commission to provide investors with quarterly account statements detailing information about the private fund performance, fees, and expenses. Two, it would require registered private fund advisors to obtain an annual audit for each private fund and cause the private fund's auditor to notify the SEC upon certain events. 3, it would require registered private fund advisors in connection with advisor-led secondary transactions to distribute to investors a fairness opinion and a written summary of certain material business relationships between the advisor and the opinion provider. 4, it would prohibit all investment advisors, registered or unregistered, including those that are not registered, from engaging in certain activities and practices that the release spells out the Commission's belief that are contrary to the public interest and the protection of investors. And finally, it would prohibit all private fund advisors from providing certain types of preferential treatment that have a material negative effect on all investors, while also prohibiting all other types of preferential treatment unless disclosed to current and prospective investors. So you have the quarterly account statement, you have the required audit, you have the fairness opinion on advisor-led secondaries, and then you have the certain transactions, which I'll let others get into, that are prohibited, and then the disclosure element around preferential treatment, and then certain types of preferential treatment that are prohibited. So this is a big deal. There's no question this is a big deal. We're in the comment process, so I'm limited in the things I can say, and I'll let the others. I'm sure they have a lot of opinions about it. I will say that from examination standpoint, there's a lot going on, and you've seen our risk alerts, and we're going to talk about that later. We have the marketing rule, which we will be examining for in November. Right, so that is a rule that is coming. It is directly applicable to private fund advisors explicitly, and I can tell you in examinations we are absolutely training and preparing to examine for that. I think a kind of broader message, which I'm going to come back to a lot today, is that compliance needs a seat at the table at private fund advisors. You can see all the proposed rules out there. You can see the rules that are coming. You can see the risk alerts. If you understand our examinations, we are not looking for checklists of very high level, technical Advisors Act issues. We are looking for, and this is not on CCOs or compliance staff. This is on portfolio managers and senior level staff at private fund advisors. They need to bring in their compliance staff now, if they haven't done it. Make sure they understand the business. Make sure they understand the LPA. They've got to understand the LPA. They've got to understand the PPM, and they've got to understand the issues that are there, the friction points that are there, and get them trained on those issues. And that is an issue now that needs to be done. And when we see it done, it's very impressive. But if anything at all, again, this is a proposal, but I mean, if anything at all makes it across the finish line, that is going to be an issue that is going to be even more significant going forward. So I think my general theme here is new rules are coming in the marketing rule in November. There may be other proposed rules that will be adopted, and now is the time to make sure that compliance really has a seat at the table, really understands the business. Because I don't think that it's going to work otherwise. They need to be integrated.
Thanks, Chris. I think that's a great point. I mean, I think if we see any of these proposals adopted as proposed, they'll be virtually impossible or impractical to comply with unless compliance is really in the weeds on some of the commercial terms that have been proposed as modified or prohibited. So I think those in the room, and we certainly in private practice have taken that away from the release. The other point I'll quickly make before our next question is that in Commissioner Crenshaw's speech earlier this morning, she noted that some of the prohibitions have been read as starkly new, but really even under the fiduciary interpretation, advisors are prohibited from acting in any way that's not in the best interest of their clients. I think those of us in the industry that sort of see some of the conflicts that exist on a daily basis would recognize that that's sort of a stark statement, and is not necessarily always practical because the business by itself presents a number of conflicts. So it will be interesting to see how people react to that, whether that statement is brought up in particular in the comment process. But moving on, Andrea and Sean, I think, we were all sort of expecting some reforms, given the public statements, particularly from commissioners over the last several months. So I'd be curious for, at least what the initial reaction was kind of out of the door at your firms. Maybe Sean, we can start with you.
Yeah, sure. It certainly is the most significant rulemaking for private fund advisors and private funds since Dodd-Frank. When I initially read it, I really think that it can fundamentally and will fundamentally change some of the dynamics and relationships between private fund advisors and their end investors, both in the U.S. and outside of the U.S. The dynamics in terms of the negotiations of an LPA, the dynamics in terms of just the ongoing communication between private fund advisor and their investors. One of my initial reactions was relating to the transparency kind of initiative within the rule, and undoubtedly it will benefit end investors, and I have a question about the sort of cost benefit analysis in terms of the transparency. There will certainly be significant costs on advisors, and those costs are somewhat varied. You'll see direct costs, I think, in terms of having to increase your compliance resources, increase your fund accounting resources. I think that there are also kind of costs in terms of service providers. I think there will probably be increases to auditor fees for some managers that outsource some of their compliance and some of their fund accounting. Those service providers will likely increase their fees. And I think there's some sort of intangible costs too, which comes with all rulemaking, which is just the cost of implementation. Here, though, I think it's touching on other parts of the business that other rulemakings have not, which is, sort of investor relations. The quarterly statements, you're going to be presenting a lot more information to your limited partners and your investors, and some of them will get confused by it. Some of them will see it as compared to another manager and try to understand, why they're getting this information from this manager and present it in this way, and it presented in a different way from another manager. And so the investor relations staff, I think, in capital development is going to need to be trained and well-versed in some of these new kind of transparency-related requirements. So that was one of the initial reactions that I had.
Thanks, Sean. Andrea?
Thanks, Sheena. Just before I begin, any opinions or personal views that I express are my own and not those of JP Morgan. So in terms of our initial reactions, the proposed rules, in our view, really represent a paradigm shift from a disclosure and principles-based regulation of investment advisors to more prescriptive requirements. And it's been customary for sophisticated parties, advisors, and investors represented by counsel to negotiate market terms in private fund transactions. And so contrary to the approach in prior rulemaking for private funds, under the proposed rules, certain long-standing commercially accepted terms are simply not permitted, even with disclosure and informed consent. So it's a departure from the past practice. But I would note that some of the proposals follow industry best practices, and some of the concerns that are addressed in the proposals have been mentioned in risk alerts by the SEC and in recent speeches. So in some ways, not a surprise. I do agree that the rules will bring increased transparency in private funds. And as Chris noted, given the nature of the regulations, compliance will need to become more embedded in the business. They'll need to have a seat at the table if they don't already, and I think that will help certain shops in enhancing a culture of compliance. And I've noticed in my own organization, just by virtue of the recent SEC activities, we've seen so far this year more senior level business attention on regulatory and compliance issues. It's higher on the agenda. And I would also echo Sean's comments about the cost. We're certainly kind of aware of the significant costs that implementing these new rules will have.
And I'd say that, you know, at least from a sort of law firm perspective, that's generally been our impression as well. I think folks are most confused by the idea that the SEC is proposing to regulate transactions between sophisticated parties after not long ago in 2019, the fiduciary interpretation seemed to suggest that, you know, that sophisticated parties are just that, they're sophisticated and sort of able to fend for themselves. I think, you know, if folks in the room have seen Commissioner Peirce's dissenting statement, that was a significant amount of what she was saying. And certainly that's I would say has been an industry reaction that we've seen, and I think would agree with. Okay, so I think next we'll turn to a few specific aspects of the proposal. Before we do, the first word for first code word for the CLE credit is perception. Again, that is perception. So, Chris, I'm going to turn back to you. You know, firms are now considering how the proposal's limitations on private funds indemnifying and exculpating advisors will affect their businesses. Would you mind going into some detail on what that proposal is? And I think folks in the room would be interested in how it might relate to the staff's position on hedge clauses, including in the recent exams alert as well as in the fiduciary interpretation.
Sure. So, I mean, the proposal would prohibit private fund advisors from engaging in certain activities, and one of those is seeking reimbursement, indemnification, exploitation, or limitation of its liabilities for certain activities. I think I could leave the rest of the comments to others. In terms of the risk alert and what we're looking at for hedge clauses currently, again, this is a proposal, but what we're looking at is based on the 2019 fiduciary interpretation. What that is about is really the confusion that some provisions create in the minds of clients. And it said for retail clients, if you say, we're going to waive all right, we're not liable for anything except gross negligence, provided that we can't that nothing that we don't waive any rights under the federal securities laws, that even for retail clients, that sort of language would be confusing, and the clients might think that they have waived their fiduciary duty. That's different for sophisticated investors. It clearly said that for sophisticated investors, it depended on the facts and circumstances. And so the types of things that we're citing is when there's a blanket waiver of all duties without that savings clause, right? So if you say we're not liable for anything except gross negligence, and you're missing that language that says, of course, we can't waive our fiduciary duty, or we can't waive anything under federal securities laws, that's something that even for sophisticated investors, because that statement is not true, right? You are a fiduciary, you are subject to the Advisors Act. That is unwaivable, and it's not the effect of that provision that we're currently citing. It's the confusion it creates, right? It's not as though we see that language and we pack up our bags and leave the exam and we say, man, it stinks that they waive the fiduciary duty. There's nothing we can do about it. That's not what happens. You can't waive it. So it has no actual effect. But our concern is that language without the savings clause for even for sophisticated investors, and we actually know this because we've talked to sophisticated investors and they are confused about it. So there's no fiduciary duty. And yes, there is. And so that's what's in the risk alert. That's what we're currently reviewing and looking at. Is these kind of just blanket waivers without making clear that, of course, you can't waive it. For retail clients, that standard is even higher because the view is that would create confusion. Obviously, that is different than what is in the proposed rule, and I'll let you guys comment on that.
Sure, and I think a lot of people in the industry are viewing these as related topics, right? Like the idea that a hedge clause can and cannot, may to a certain degree set out an advisor's responsibility and a fund indemnifying an advisor for anything that's not negligence. Folks are viewing that as somewhat related and are, I think, for better or for worse, somewhat confused about the positions. I'll turn to Andrea and Sean in a second, but one thing I wanted to note here is that for folks that are interested in the comment process, there are a number of questions, obviously, throughout the release. There's an interesting subset of questions on state fiduciary duties and whether the SEC should comment or the final rule should include, a prohibition or any sort of language on whether advisors should be permitted to waive any duties that they have under state law. So just want to flag that for folks in the room. And I think we'll turn now to Andrea and Sean. I mean, certainly if you have anything to say on the fiduciary duty hedge clauses or the limitation on liability, please chime in. But Andrea, generally speaking, which commercial proposals would you highlight as most problematic for your firm at this point?
Well, we're focused on the prohibitions on commercial terms. Again, it's a departure from the previous rulemaking, which was more disclosure-based. We are focused on the limitation on certain types of indemnities. It does suggest a movement towards a strict liability standard for fund advisors as opposed to gross negligence, which is typically the liability standard across many private fund documents. So this could have the effect of just increasing the potential liability for advisors, risk exposure, likely insurance costs. And then this increased cost of doing business may ultimately impact the fees that are charged to investors. And it may impact day-to-day management of portfolio companies, what advisors are willing to do and the risks they're willing to take. Another prohibition that's concerning is the broad prohibition on calculating GP clawback net of taxes. So that may require advisors to repay more carried interest distributions than they've actually received on an after-tax basis. And then if that's adopted, it could have a very real impact on fund economics and on market terms. While it's possible we may see more kind of whole fund or European waterfalls rather than deal by deal, sponsors may be less likely to agree to clawbacks in general, or they may reduce the circumstances under which clawbacks apply, which would be a worse result for investors. And that could also result in higher management fees or higher overall carry to compensate for the economic hit potentially from this proposed rule. And one other thing I'll note about the prohibitions is that there's no grandfathering. So if the rules are adopted as is without grandfathering, once effective, many funds will have terms like indemnities or hedge clauses and GP clawbacks that are inconsistent with the rules. And so we may need to do a full-scale amendment of fund documents and side letters to comply, opening up fund documents, especially for large managers with a broad LP base, will bring administrative and operational challenges and costs. There may be renegotiation of other terms like fees, and there'll be a cost to advisors and investors in the renegotiation and redocumentation. It's even possible that some advisors may terminate existing funds early and raise new funds with compliant terms and increased fees and renegotiated side letters. So there could be some market disruption, which could impact returns, amount of capital available for investment, and the operations of portfolio companies.
Yeah, and I'll just note on the after-tax GP clawback, I think a common sort of comment that we're hearing from the industry is that it doesn't sort of accurately represent the way that practice works. So again, would encourage folks to look at that and see how often this is an issue for them and whether it actually is possible to comply with given the way that those clawbacks work. Sean, I'd like to turn to you now. What would you say are some of the unintended consequences of the rules? I think we've talked about some of them, but maybe for the group, if you could just highlight what those may be.
Yeah, sure. I don't know if some of the consequences are intended or unintended.
Fair.
But just turning to the kind of standard of care point that Chris was talking about, I agree that currently there is a difference between current space and the rule proposal. And what's interesting to me is to try to think about kind of the practical impact of that. And I think a prohibition on indemnification for negligence. If you're a manager that has, that invests in early stage tech companies or just any sort of early stage business, oftentimes the investment professionals are, very technically oriented and hands-on with the portfolio companies and are constantly giving advice and are just really advisors to the portfolio companies. And I think that one of the consequences of this change in the standard of care could be a little bit of a chilling effect on those investment professionals because they don't have the same protections. So I think that's just sort of an interesting consequence of that change to the standard of care. In terms of other consequences, I agree with Andrea that the lack of grandfathering will create a significant hurdle operationally for most managers. In addition to that, the preferential treatment restrictions, I think there are some interesting consequences, particularly with respect to the pre-investment disclosure of preferential treatment. I think within kind of the investor base, you'll have different clients who value that differently. There are certainly some LPs that value their client-specific reporting, their client-specific fee arrangements, and they value the confidentiality of those. So query whether or not this will cause some of those investors to want to move more towards a single investor vehicle, a managed account. And then there's an unintended consequence of that, which is that you kind of lose the economies of scale of a fund. With respect to the prohibited activities, specifically the requirement to charge fees and expenses on a pro rata basis amongst all clients within a transaction, I think that will have an impact, particularly in the co-invest space. It's not uncommon in the co-invest space to have expenses borne by a primary fund and the co-invest fund, not pay some of those expenses. One that specifically comes to mind would be broken deal expenses. That's oftentimes, paid by the primary fund. So, this could be kind of a fundamental shift in the co-invest space, and I think that's kind of an interesting consequence as well.
Yeah, absolutely. I mean, I think as well, just sort of piggybacking off of the co-investment point, co-investors so often brought in to sort of prop up a fund investment, for lack of a better term, and the capital is very rarely sort of solidified until right at deal close. So it's hard to even get those investors to commit to to co-invest expenses on a pro rata basis before the deal has really crystallized. Thanks, Sean. That was very insightful. Chris, I want to make sure we touch on one aspect of the proposal that's not exactly part of these commercial terms, and then we can come back if we have more time. There is this new requirement to document compliance reviews, and I suspect that Exams has had a lot of exposure to different types of compliance reviews at different sort of levels of detail, and had to sort of evaluate them on a somewhat subjective standard. I think as practitioners in particular, there was an interesting aspect in the proposal about treating documents that are either ancillary to or part of a compliance review as privileged. And the SEC in the proposal suggested that because compliance reviews are required to be produced to the commission, or now will be, those documents cannot be privileged. So Chris, I appreciate that because we're in a comment period, you're limited in terms of what you can say about the proposal, but curious if you can sort of talk to us about your experience at Exams in dealing with annual compliance reviews and what some of the challenges have been that may or may not have led to this proposal.
Yeah, so I think it's best to start with best case scenario, which we do see, which is this is really a chance for compliance staff to show us their homework and what they've done. And it's from my perspective, I think perspective of most people in Exams, when you go into an exam and they say, here's everything we did last year, here's everything we looked at, and we found a problem and we fixed it, that creates tremendous trust with the exam team. Tremendous trust. Not everyone's perfect. Certainly we're not perfect. Certainly, firms aren't perfect. There are problems. And I think the more you can show us, the more work you can show us, the better we'll feel about kind of finishing up and moving on, because we we generally do view CCOs and compliance staff as our partners. They're on the front lines. They're the ones making sure that the firm is complying with the Advisors Act and all the applicable rules. So the more you can kind of demonstrate that you're doing your job and you're getting the cooperation and the buy-in, more importantly, because it's usually not the CCO that's the problem, it's senior staff. The more you can show is that you're doing your homework, you have buy-in, you had a robust review, and you found a problem or you didn't find a problem, but you fixed it or you're in the process of fixing it. Just be honest with us, and that's tremendously helpful. And I think that when you see kind of whitewashed annual reviews where it's like a kind of vague checklist, and you say we found nothing for the past 10 years, and we've got no support documents for it. That's not going to create a lot of trust with the exam team, and they're going to wonder what's underneath it, what you've done, whether this was an actual annual review. So again, not speaking to anything in the release that's under proposal, but I think currently today, the more you can demonstrate to us that you have taken that annual review process seriously and you found problems and you fixed them, that is going to go a really long way to kind of speeding up the exam and making it clear to exam staff that you're a partner who has access to the documents you need, to the people you need, and that the process is working. So I think that's what that's a lot about. As you move from kind of the ideal situation down, again, currently it's not required to be documented. So if you said we did an annual review, but we have nothing to show you, except maybe a memory of it, that's challenging. I mean, because exams is a document-heavy process, right? Especially now where we're currently in a virtual positioning where we're doing everything by Zoom or WebEx. We really like to see documents, and documents help us do our job, so we can get out of your way and let you go back and do your job. So the more you can show us, the more you can demonstrate the work you did. Show us your homework. That's really, really helpful. Kind of regardless of what happens with this proposal.
And I think just from a practitioner's perspective, if I can comment briefly on that language in the proposal, if it makes it into the final rule in some form, I think there are going to be some serious questions about where we draw the lines in terms of what is privileged and what's not, because we're required to produce something as part of the written annual review. But there is, as Chris says, a lot of homework that goes into it. And perhaps, some of that is appropriately presented to the exam staff, and some of it is better left privileged. But I think, we're going to be having some of those conversations. There are some questions about whether the SEC can say what is subject to attorney-client privilege and whether that's within their purview. So curious to see if folks address that in the comment letters as well. Andrea, we have a little bit of extra time, and I know that you have some feelings about some of the prohibitions on preferential treatments and side letters, and that's an important issue to you. So I just want to, make sure you get a chance to address any additional points on that one in particular.
Sure. One point I'll make is that while there are not many terms that are prohibited from preferential treatment if they're properly disclosed under the proposed rules, there are some questions in the release around preferential treatment that are concerning, and that they suggest that the SEC is perhaps contemplating making the restrictions more onerous. The release asks whether the SEC should prohibit all preferential treatment. So there's some concern about potentially moving to a place where disclosure and informed consent would not allow any preferential treatment, Pandora's box, so to speak. So wanted to just emphasize that.
Yeah, that's a great point. And I think thematically, certainly the questions in the proposal suggest that whether, really, or just to make a point, the SEC was saying this could have been a lot worse. And maybe it still will be. That's certainly not what I'm hoping for. And I don't think anyone in the room is either. But I think, and this is a great segue into the next question about the comment process, but, just generally speaking, and Chris, you may make this point as well, I think folks should look closely at the questions that were asked. There are some sort of general reactions to the proposal, which I think will go far, but really, I think the more specific we can be as an industry, the better it is in the response process. So, Chris, I'm sorry, I may have just stolen the answer to this question, but I know you're limited in what you can talk about. Maybe you can give us a sense of sort of what the comment process looks like generally at the agency, if you can't talk about this comment process and you know, kind of what this might look like going forward.
Yeah, so there's a comment process, and people will submit their comments, and I expect there will, this will be probably a record-shattering comment period. But then the staff has to deal with those comments and take those and evaluate everything, and if it proceeds, then it will go to adoption. There will be a draft adopting release where, a lot of that adopting release will be addressing comments one way or the other. We made changes because X person made a comment. We didn't make a change because we received, support and this makes sense. So, the comments are very important. I mean, it's a critical part of the rulemaking process. And, after that plays out, if the commission decides to proceed, there'll be an adopting release and there'll be a vote on that adopting release. And if it's approved, then that will be the rule. And we will get to work in the Division of Exams and learn it and examine for it. If not, we won't. There could be significant changes. You certainly have seen that in the past where there are changes in between the proposal and adopting, but ultimately that's up to the commission.
And actually, on the comment point, I think many people in this room know that the comments are due. I think it's April 11th. But this week, a number of trade groups filed a comment letter. IAA was one of them. It was a joint effort to ask for more time on comments. So we'll see if that sort of goes anywhere. But I think folks are at least hopeful that point has been made. Okay, I want to make sure we have about 15 minutes left. I want to touch on the exams risk alert as well as PF. So maybe we can just transition to a brief discussion about the risk alert and how it will shape compliance. Chris, could we ask you to sort of summarize some of the key issues? What did exams identify as problematic or patterns? And maybe how should compliance teams really react to the risk alert?
Absolutely. So risk alerts have been a huge priority for the Division of Examinations the past 5 or 6 years. We've really put a lot of energy into it because CCOs in particular said, we want to know what you're seeing. And fair enough. I mean, we put all this energy into examinations and, unless, unfortunately it gets all the way to an enforcement action and you can read some of the facts, but even in the settled orders, there's often not a lot of detail. And that's a very rare case, right? There's a lot more behind it. Short of that, or your own actual deficiency letter that you received, there just wasn't a lot of detail about like what we're looking for and what issues we're finding. So we really put a lot of effort into this because we understand and we've heard that this both informs compliance staff so they know what issues we're looking for. We absolutely are not trying to play a game of gotcha. We want everyone to understand clearly what we're looking for and to comply with it. And it also gives them leverage because it's one thing to say, I think this is an issue. Someone told me that this was cited on exam versus here's a risk alert from the Division of Examinations. If this is an issue, we need to fix it. So both informing and also providing leverage to exam staff is to compliance staff and CCOs is really our goal with these risk alerts. And the one that came out January 27th, I promise you this was not part of some grand scheme. This was really the second part of the June 2020 risk alert under Chair Clayton, who wanted to put out, he really wanted to put out a risk alert on private fund advisors. And so we really picked the top 3 issues that were really specific to private fund advisors. And so we picked conflicts of interest, fees and expenses, and MNPI code of ethics. And we really wanted to make sure we got those out. We had other issues that we wanted to that just didn't quite make it. And that's always kind of been in our back pocket. And so that the second half of that risk alert is really what came out in January 2022. And in that are kind of a catch-all provision, which is conduct inconsistent with disclosures. And like, what exactly is that? It just basically means you don't follow your LPA, and it's not kind of directly related to fees and expenses, with one exception that I can talk about. And other issues in the LPA that weren't followed, also not directly related to conflicts. Although, again, all this stuff kind of comes together. But we wanted to tease out sort of the issues that maybe didn't receive a lot of attention, kind of very technical issues from LPA compliance that we wanted to get out there that didn't make the cut the first time around. Performance and marketing. Honestly, part of the reason that wasn't included, I think we were in the comment period for performance and marketing back then. And so that made it difficult to get that in the June 2020 risk alert. And so, but that's something we've always wanted to get out there, because I think there are some important issues. Now, this isn't under the new rule, but I think the kind of the spirit of it, these are issues that likely I think would be issues under the new rule as well. And we certainly cite the new rule as something that folks should look forward to. Due diligence, which is mostly about kind of following disclosure about your due diligence or following internal policies and procedures about your due diligence. That's something we wanted to get out there. And then hedge clauses, which again is different than the proposal, but is something that we've seen and kind of emanated from the 2019 release about, not making clear that of course we cannot waive our Advisors Act fiduciary duty. That's just not possible. It's not happening, and we just wanted to make that clear. So, I really encourage you to read the January 2022 one, the June 2020, which is really the top 3 issues. And I would also encourage you to read the November 2020 OC observations about investment advisor compliance programs, because that is about all investment advisors, but it really kind of clearly states our view of the value of the importance of compliance, the resources that should be devoted to compliance, and certainly that is true for private fund advisors, maybe more so, frankly, than other types of advisors. So I think if you're a CCO and you really read those 3 risk alerts and understand them and understand the issues, and look at your own firm and match them up against these issues, that should really go a long ways for you to understanding what exams looks for currently under the rules and regulations. So, we really spend a lot of time on this. We really think about what we can highlight that would be helpful, that maybe people are missing or that are a little bit nuanced or complex. And of course, we do this in all sorts of different issues. We have, we publish risk alerts for all types of different types of registrants. But for private fund advisors, I think these 3 are really critical in understanding what we're really looking for on exams.
Thanks, Chris. So, Andrea and Sean, I think I'm just going to open it up to you. I know that in our discussions we had sort of, Andrea, you talked about some overarching observations, and Sean, you talked about some aspects of the risk alert. So feel free to comment. Maybe Andrea, we can start with you.
Sure. In reviewing the risk alerts, we certainly noticed some continuity between them and the proposed rules that came shortly thereafter. It was somewhat of a preview. The most significant item was around hedge clauses being potentially inconsistent with the Advisors Act. And then that theme was carried through, although not exactly, but the theme was carried through in the limitation on certain indemnities that we saw in the proposed rule. And actually, the risk alert was cited in the proposed rule around proposed indemnities in the footnote. And as discussed earlier, that can have a real impact on operations and liability profile and the economics of funds, and is a movement kind of away from a disclosure-based regulation to more prescriptive. And then aside from the hedge clauses, most of the observations in the risk alert were along the lines of what we've seen before, although with more granularity and specificity, like really showing that the exam staff is really digging in on exams. Many of the observations were around funds not operating consistent with their disclosure or operative documents. And we saw that focus on compliance on fund documents. It was emphasized in the proposed rules with the requirement for quarterly reports to cross-reference governing docs. So another tie-in. And as Chris mentioned earlier, compliance really needs to know the LPA. There's a real focus on referencing and being consistent with operative documents. And finally, I would just indicate that it is helpful, I agree, to have the risk alerts and to learn what's on the SEC's radar, and it gives us the opportunity to make sure that the issues highlighted are ones that we've addressed in our practices and policies and procedures. I recently saw that the November 2021 risk alert on fees was helpful to compliance and the business in reviewing the fee disclosures for our Form ADV update. So just one example of how the risk alerts can be helpful in practice.
Yeah, and hopefully this is music to your ears, Chris, but we actually look forward to the risk alerts. We think that they are very useful tools for compliance because they help you prioritize what you're going to do that year or subsequent to the release of the risk alerts. You know, I think just as a practitioner, we use them, we kind of take them, we review them, we decide what's applicable to our business, because the private fund business is vast and varied, and there will be certain aspects that aren't applicable to any given kind of manager. And then we perform a gap analysis and kind of figure out, you know, where we need to increase our scrutiny. But they are also a helpful tool with kind of, you know, commercial counterparts to say, you know, you're not just hemming and hawing and saying, you know, there's increased scrutiny here. You can actually say, hey, here's a risk alert. This is something that's actually being reviewed closely. In this particular risk alert, you know, we kind of focused on making sure that our practices did align with our disclosure, whether that's the LPA, PPM, or elsewhere. You know, really digging into our pre-investment checklists to make sure they really addressed LPA requirements in all different contexts. So really do think that they're useful tools, and I hope that they come in the future.
It's quite the endorsement. That was a marketing role joke for those nerds in the room. Before we just wrap up, I'll give you the second CLE code. That's value. We're not going to have very much time to talk about PF, but I do want to touch briefly on that proposal. By the way, thanks Andrea and Sean for your insights on the risk alert. So just a brief overview on the PF proposal. I think generally the feedback has been that the two most problematic elements of that proposal, at least for private equity funds, has been the one business day reporting piece, as well as the decrease of the sort of AUM threshold for large private equity managers. Chris, I think it would be helpful for folks to know kind of how the commission has used PF historically and the role it plays within the various divisions. If you could give us a little bit of color.
Yeah, absolutely. So we use Form PF. We use it for risk assessment. We use it to get an understanding of the firm before we go in. So in examinations, we absolutely use it. It's certainly, you know, I know from in the Division of Investment Management and DERA and other places, you know, it's used to monitor trends, you know, kind of across the marketplace and see what's happening, or if there's events that happen in the world, you know, there's certain information so you can see who might have exposure or issues regarding certain classes of securities. But you know, it's very helpful to exams because it allows us to have before we go into an advisor, private fund advisor, it gives us a snapshot of, you know, your funds, what they do, how big they are, leverage, et cetera. So it is very valuable information for the Division of Exams, and you know, the proposals out there for some changes to it.
Andrea or Sean, any final reactions to or final comments in general, or reactions to the PF proposal in the 1 minute and 27 seconds we have left?
Sure. You know, I think generally, I think the substance of the proposal is going to be workable for most managers. And we're going to be focusing on the other rules. But the one business day reporting requirement, I think that is, it's quite strict. And to me, it's kind of interesting. If you think about other disclosure and reporting requirements for private funds, I think of the ADV and when are you required to kind of do an amendment, and other than annual amendment, when there's a material change. So I wonder if it's a little bit of a departure from that kind of materiality requirement to an actual strict one business day requirement.
Yeah, we also are challenged by the one business day requirement. In my experience, in large financial institutions with many constituencies and control functions, operating internationally across time zones, a one business day turnaround, especially for a regulatory filing, is extremely difficult. And so query whether the costs of the increased volume and frequency of the reporting in the PF proposal really outweigh the benefits. And we wondered, do the proposed changes advance systemic risk monitoring, which was the original purpose of Form PF? And at least on the private equity side, a lot of the trigger events are not ones that are likely to create systemic issues that would merit a one business day turnaround time.
Great. Well, I want to thank my fellow panelists. Thank you so much for all the hard work, and thanks everyone here for your attention.
Thank you.
Yeah, thanks.